and a warm welcome from Cape Town. It gives me great pleasure to welcome my co-presenter, that's Professor Stephen Jeffrey. Stephen, good afternoon to you from a magnificent Cape Town, of course, our technician, our pelvic floor foundation person, that's Karin. It's a great pleasure to have with us this afternoon Mr. Daniel Kidd, who's a lawyer. Now, I don't usually give the bios because anybody, there he is, Daniel Kidd. I don't usually give the bios because anybody can Google the bios. Nowadays, when you have a congress, you don't give bios anymore because 2 or 3 minutes of the poor guy's talk is his CV. So if you wanted to do a bio of Daniel Kidd, you could. I just want to say 1 or 2 things. It is a qualified advocate. He completed his law degree with economics at the University of Stellenbosch and practices in insurance law. He also is a director now at the firm of Everings Attorneys. He used to be from 2011, he's now the director of the firm. He has a wide range of complex commercial insurance disputes for local and international clients and specializes, ladies and gentlemen, in indemnity litigation, medical malpractice, and general liability claims. He's talking this afternoon on mitigating risks and challenges of stand-in doctors. And it's a great pleasure to have him with us, Steve. Just to remind you that next week we've got Stump the Professors. Our professors are Professor Stephen Jeffrey, a urogynecologist. So if you have any questions regarding Stephen Jeffrey, please stump him. There's Professor J.P. Rubus, head of chief of the Department of ONG. It's Amsterdam University. There's Lisa Welsh, who's an accredited sex educator. There's Deline van Dijk, psychosexual sex educator, counselor, and sexual health nurse. There's Dr. Sameshni Mutli. We've heard her a few times. She's the MD and product manager for stem cell banking and newborn screening. Of course, Clayton Hall, we had him last week, and he was a great hit with medical malpractice. And then Sherry Palm, she's the APOPS founder and CEO. Steve, what's APOPS?
I don't know.
You don't know either.
Something about
Karin, tell us.
It's APOPS. It's
I could also say APOPS. What does it stand for?
Let me get the exact wording, but it's for collapsed prolapse, for the prolapse organ. But let me get the exact
prolapse organ. All right, so she'll be talking
Prolapse
about
Organ Association.
Oh, the Prolapse Organ Association.
But let me get the exact wording for you.
Okay, 7 professors you've got to stump, and that's next week. That's going to be a wonderful thing. And send your questions already so we can put them to the professors so we can stop stumping them as we speak. So
it stands for Association for Pelvic Organ Prolapse Support.
And she's the founder and CEO.
Yes.
So we're looking
she's
forward to
joining
sharing.
us from the States.
Yeah,
she's an American.
Yeah. So she knows Dr. JP, Prof. JP.
Prof. JP Rufus.
Okay,
Yeah.
good. A lot of Urogyney people there on. Anyway, yeah, good. Well, we can get this session started. Thanks so much, Daniel, for agreeing as well from our side. Daniel's been he's a great support, I think, to doctors who are do end up in some sort of legal issues, and I have helped him a little bit with some of their cases, and it's and as I say, it's always nice to work with Daniel. So great to have you on the session tonight, and I think you can fire away and start sharing your screen.
Who's our sponsor tonight, Steve? Everingham's. All right, we'd like to thank Everingham's very much indeed for sponsoring this evening's presentation.
It is what it is.
Right, can I go for it?
Go ahead.
Great. Just checking, can everyone see my screen, hey, Stephen?
Yes, we can see your screen.
Great. Okay, I'm just going to open the Q&A box as well. So yeah, thanks everyone for attending, and thank you to the organizers for the opportunity. It's good to be here. Just before I start, I just like to encourage questions, please. I hate talking into a void, so please feel free to interrupt at any stage. You're not going to kill my flow.
We do have a tradition of interrupting the speakers, so we will do that.
We'll do that.
No, I like it that way. So that
we already have a couple of questions, but I'll keep them for halfway through, Daniel.
All right. Okay, that's fine. Okay, so my topic today is mitigating risks and challenges of stand-in doctors. Now, I try to talk about this often because we've seen a lot of cases where the confusion between doctors as to whose patient is whose patient becomes quite important, and we sort of try our best to educate as much as we can to avoid legal action. You may think it disingenuous that an attorney would want to encourage the avoidance of legal actions, but you can chat to Stephen about how I see things. I think the landscape of the litigation in the medical malpractice industry at the moment is very unfortunate, and it simply has to change. And the only way to do that is to firstly fight these cases hard, to make it less attractive for my colleagues who I call the personal injury lawyers, and also to avoid claims. I mean, if there's no incident, there's no claim. So our firm focuses on risk management. It's a big part of our practice is to try and prohibit these events before they happen. So that's why we're doing these sort of talks, is to give you some insight on the claims trends that we've seen, and some of the pitfalls to avoid. All right, so we can get into it. Okay, so just a bit of an introduction as to where we're going to go. We're going to deal with what is a stand-in doctor, what's the role of stand-in doctors, the legal basis of it. We're going to deal with liability of stand-in doctors, lessons with some case law that we're dealing with, some cases that we've seen in the past, and some reported judgments. We're going to go through those. And as I said, please, at any stage, feel free to ask a question or to interrupt me. I've got the Q&A box open next to me. Okay, so just as a generality, this presentation provides a comprehensive guide to mitigating risks and challenges of stand-in doctors during healthcare transitions. The aim is to provide insights on how to best attempt to navigate such transitions seamlessly. The presentation will cover topics such as identifying potential risks, developing strategies to mitigate them, and implementing best practices to ensure a smooth transition as far as possible. Now, what's quite important to point out from the get-go is that we as lawyers we've never been doctors. So we've never been in the coalface. We judge everything retrospective, well, yeah, in hindsight. So there's a certain way that we see things, and there's a certain way that a judge sees things. And the only people who can really give us insight about actually what happens in practice are the doctors. So when I go through these scenarios, just be mindful that the facts that I present is what I've seen in practice. Your practice might be completely different to what I'm presenting here, and I'd like to know about some of the challenges that you've faced. Say, for example, there was a unique set of circumstances where one doctor was standing in for another doctor, and you would like to further open for discussion. Please do that. Okay, what is a stand-in doctor? In generality, the stand-in doctors are healthcare professionals who temporarily fill in for other doctors during transitions such as vacations, sick leaves, and scheduling conflicts. While they play a crucial role in ensuring continuity of care, they can also pose risks and challenges if not managed properly. And understanding the role of stand-in doctors is essential in mitigating potential risks. So the role of stand-in doctors, obviously temporary patient care.
Sorry, Daniel, is a stand-in doctor the same as a locum?
Yeah, locums the term locum can be confusing in a legal context because, for example, a lot of ER units use locums. Well, some of them exclusively use locums. So in that sense, I don't see it as being the same because there's much more of a closer employee-employer relationship in those circumstances. Whereas a stand-in doctor, I mean more in the context of a specialist using another specialist to look after their patients. So although the term locum tenens can be used, I just think it's safer from a legal point of view just to refer to stand-in doctors. But for all intents and purposes of this discussion, there's no real difference.
Okay, thank you.
Okay, so temporary patient care, responsible for providing care to patients in the absence of the primary doctor. So may prescribe medication, diagnostic tests, develop treatments. Obviously, patient assessments is quite an important part of this, and obviously consultations with the patients is quite critical. So one of the things that I'm going to emphasize is the question of communication between these doctors. So in my experience, especially with gynecologists, it sort of seems to me that the doctors work in these little clusters. Usually have about between 2 and 4 doctors, depending on the size of the hospital. And there's usually a standing arrangement between them as to how they deal with overtime, how they deal with being on call, and so forth and so forth. And the cases that we've seen where the ultimate result for the patient was problematic is almost always caused by a lack of communication between the specialists. In other words, if a doctor, for example, goes away for a holiday, and there's a patient coming in, or there's a patient already in hospital, either the patient's condition wasn't properly communicated to the doctor taking over, or there's some sort of other fault in the communication. So I just want to emphasize before I go further that communication and teamwork, I suppose, between these doctors, or between the doctors in a cluster, is of vital importance. All right, now, of course, documentation, massively important. I mean, specializing in this field, we've seen pretty much everything when it comes to record keeping. We've seen the most incredible sort of filing systems and methods of record keeping of certain practitioners, and we've seen woeful record keeping in others. But just as a generality, the issue of record keeping is also considered by our courts as being extremely important. So it's almost, if you get into a courtroom and a judge sees that that you haven't kept proper clinical notes, for example, it's almost like you're starting off on the back foot already, because it gives the judge a sense that this is not an important patient to you. You know, so I'm not sure what everyone's record keeping is like. I know admin can be a burden and nobody likes it, but just to emphasize how important that is, especially when things do go south, that the record keeping is in place. All right, and then obviously the issue of informed consent, which we'll deal with a bit later, of vital importance as well, because in this transition period, you're obviously dealing with a situation where informed consent may have been taken 3 months ago. You know, for example, if a woman has is going to go into labor, and there's an informed consent signed that she wants to have a C-section in case of natural birth not being a feasible option anymore, then it's quite important that the doctor going away obviously needs to inform the doctor who's sticking around that informed consent had already been taken. But we'll deal with that a bit later. And then, as I've said before, communication with primary doctors is absolutely key. And then sometimes, obviously, in emergency response situations, the standing doctor will obviously have to treat a patient of another doctor. And that's in particular where the documentation and record keeping aspect becomes very important. Okay, so the legal basis of stand-in doctors. Now, I'm going to try not to be overly legalistic, but in essence, what a court looks at, there's 2 scenarios. So when you delegate or when you refer your patient to a stand-in doctor, there's 2 things that can potentially happen. Either that stand-in doctor can be regarded as one of your employees. In other words, that would result in vicarious liability on your side, or that standing doctor can be seen as an independent contractor. Now, let's deal firstly with the employee or the vicarious liability aspect of the matter. So I'm not sure how many of you have actually heard that term, but essentially vicarious liability means indirect liability for the actions of another person. It usually becomes relevant in the context of an employer-employee situation. In other words, your employees, if you employ them, in other words, you have an employment contract with them, you would generally be liable for their conduct. In other words, it's something that it's also called faultless liability in a sense, because you, as the employer, have done nothing wrong. You are only liable because of what your employee has done. Now, the law on vicarious liability is vast and extensive, and I'm not going to go into too much detail. The reason I mention it here is because it has been argued in the past on the part of patients that if a doctor relies on a stand-in doctor to treat the patient, then he ought to be vicariously liable for the stand-in doctor, because that doctor is essentially furthering his interests. Now, as I'll explain later, that argument has since been rejected by our courts, and a stand-in doctor is regarded as an independent contractor. In other words, as a generality, you as the primary doctor should not be liable for the conduct of the stand-in doctor. Now, there are a few exceptions, which I'll also deal with. I just see the question. Okay, there's a question here that says, usually a stand-in doctor would have full permission to treat the patient as is needed. What if the primary doctor is not accessible? Obviously, communication with a primary doctor will not be possible. Is that a problem? Yeah, thank you. That's from Pramila Naidu. That's a very good question, and also something that we've seen in practice, that the stand-in doctor, or that the primary doctor goes into the bush somewhere, switches off his or her cell phone, and is never heard of again until about a month later. Yeah, that is a problem that we've seen, and the only solution that we've got to that is the communication must be proper and comprehensive before the doctor leaves. So again, it's all about the unique circumstances. So 95% of your patients will be routine. In other words, you don't need to go into a lot of detail because your stand-in doctor would know exactly what to do. But you do get those patients, like let's call them the 5% patients that are problematic. In other words, for example, it could be relevant that the patient presented initially with a respiratory condition, which had resolved in the meantime, but there were potentially signs of it resurfacing a bit later. That would, for example, be, and I'm just using an example, something that you would have to communicate to the stand-in doctor before you leave. But again, it's all about the unique circumstances. We as lawyers can only in hindsight judge what ought to have been said at the time. It's up to the doctors and the specialists in that field to know or to make the assessment as to what should be communicated to the stand-in doctor. Ultimately, your potential liability to the patient would revolve around what conduct was reasonable in the circumstances. So your conduct is tested against the reasonable doctor in your position. So yeah, I'm just checking another question here. What is the role of a backup doctor? Is it the same as a stand-in locum doctor? So that's Rafiq Bala Mia. Maybe you can just give me some more information. I'm not familiar with the term backup doctor. Is that somebody? Is that like an assistant during a procedure, or what do you mean by that? Just waiting for an answer there. Okay, in the meantime, we can move on. All right, so just getting back to the vicarious liability. Yeah, I'm just getting back to the issue of vicarious liability versus independent contractors. So in essence, to sum up that situation, we'll get into a bit of case law a bit later on. Our courts have at the moment pretty much accepted that one doctor should not be held liable for the conduct of another doctor. And as I said, there are a couple of exceptions that we'll get to, but the general thinking of our courts are, which I agree with, is that when you have two separate specialists who are both trained, maybe not have the same level of experience, than one another. The fact of the matter is you need to judge them both separately. And there's not enough to constitute an employer-employee relationship. On the contrary, it's vital for the proper working of the industry that doctors trade for their own account and practice separately and individually. All right, I'm just going to move on. It's checking no further questions. All right, just to give you an example of how the issue of vicarious liability is dealt with in practice, quite a recent case that's quite interesting is the case of Mohun versus Phillips. In this case, the patient was a 43-year-old male who suffered a brain injury after having been admitted into hospital. So at the time of admittance, he was almost unconscious. He had reportedly consumed alcohol and tablets. And shortly after, he was examined by a physician, Dr. Mohun, who was engaged as a locum tenens by the medical practice, operating as the ER unit. So important distinction in this case. So we're not now talking about two specialists standing in for each other. We're now talking about a ER unit that practices as a separate company within a hospital that employs a physician as a locum tenens. It's not the same, but it's similar. In other words, it can be compared to one another because it's you in both instances, whether it's a practice or whether it's another specialist, is relying on the locum tenens to take care of the patients. In this case, the patient was not properly monitored and his respiratory condition gradually deteriorated. He eventually suffered from hypoxia, cardiac arrest, and brain damage, and Dr. Mohun was found to be negligent. But the big question here was, should the ER unit be vicariously liable for Dr. Mohun's conduct? In other words, was there a close enough relationship that a court would not only hold the doctor liable, but also the ER unit who made use of his services? The plaintiff's attorneys argued that vicarious liability is not limited to employee-employer situations and should attach in situations where the person committing the deed is undertaking an activity which serves another party's interests, so in this case, the ER unit. So the court luckily found, and this was the Supreme Court of Appeal, luckily found that the physician is an independent contractor. In other words, the court basically denoted that the area of speciality of a physician is to such a high degree that you can't actually say that that person is being guided or paid or whatever else would constitute vicarious liability through another entity. In other words, the court emphasized that this person is so specialized that he's got to stand par for his own actions and that no other people can be held liable for his conduct. And it's the same with stand-in doctors as well. So luckily for you, if you rely on a stand-in doctor, the argument is available that that person is an independent contractor. In other words, you should not be liable for the negligent conduct of that other doctor. But where your potential liability lies is your direct potential negligence. In other words, it can manifest in various different ways, but the most important is referring to a standing doctor who is not specialized enough. In other words, either not competent or way too junior to handle this particular patient. In that case, you could be found to be directly negligent. In other words, it's got nothing to do with vicarious liability. It's got all to do with your own negligence. So that's the one way. Let's see if I check it out. There's another question here. Okay, so Rafiq has answered. If a midwife is the primary caregiver and doctor is the backup in a case of emergencies, is the doctor responsible for the care given by the midwife? So Rafiq, to answer your question as a generality, midwives are employed by the hospitals, and there's a lot of case law that confirms that hospitals and doctors are regarded as separate and distinct in these situations. So the doctor should not be responsible for the negligent actions of a midwife. That would be that would be the hospital that would be vicariously liable for the actions of the midwife. All right. Any questions before I move on? Karen, I think we can run the first poll. It's probably a good time to do that.
Which one did you have in mind?
Let's have a look here. We can do the first one. Firstly, do you have a medical malpractice lawyer of your own, or have you consulted anybody?
While people are answering that question, I would just like to ask you, how does it work with other staff, like your admin staff, etc.? You know, we often aren't aware of the sort of advice that might be given patients off and calling the office in terms of simple post-operative questions, etc.
Yeah.
Does the vicarious responsibility that obviously falls into that sort of section more?
That's a good question. Thank you for that. So that's actually a very interesting question. It's something that we're dealing with now in another case we've got. So I'm going to answer your question by using an example. So in the case that we're dealing with currently, the patient had a C-section and was then there was then a follow-up consultation. And this particular doctor had quite an interesting standard practice in place, whereby he would get a representative from his offices who's not a qualified nurse, but has had some sort of training in, can't remember exactly what it was, but he ran a few courses on gynecological, I can't remember exactly what it was, but anyway. But basically what the doctor did is he relied on this particular employee in his office to check the patient's C-section wound. And that is something that he did quite often. And it's because he's either seen patients or he's in theatre or whatever. And what had happened in this case, unfortunately, the wound was very compromised. That person in the office did not pick it up, and the doctor is now in a lot of trouble. So Stephen, to answer your question there, as soon as the person is employed by you, in other words, if it's an office assistant, anybody that has an employer-employee relationship with you as the doctor, you are susceptible to being found vicariously liable for their conduct. So just be mindful that if advice is given telephonically, that could open you up to a legal action. And I would propose that as far as possible. And again, I'm not alive always to the practicalities. You may say to me, well, Daniel, that doesn't work in practice. Sometimes we have to do that. That's an assessment that you yourself can make. From my perspective, I would advise that sort of setup in your office be avoided as far as possible, just because you've got no control over what advice is given to that patient. All right. There's a follow-up question on the midwife issue. Some midwives run private practices and work independently, however, may request a guide to avail themselves in case of a need of a Caesar. Can the guide covering the said midwife be held liable for bad outcome, although the cause may have been due to something that the midwife did? That's from Tshepo Robotata. Yeah, thank you for that question. It's a good one. It's not a situation that I've seen in practice yet. I've heard of these midwives working independently, but I would think for the same reason as previously mentioned, because there's no employer-employee relationship between yourself and the midwife, I wouldn't imagine that you should be found vicariously liable for something that midwife did. But if you are going to enter into an arrangement like that, it may be a good idea to have some documents or some documentary system in process whereby yourself and the midwife maybe sign an agreement to say, look, what we're doing here is complete opposite. We run separate practices. This is not an employee-employer relationship, and we shouldn't be held vicariously liable for each other's actions, because the midwife would be in the same position. He or she would also not want to be liable for the doctor's conduct. So it's in it's in everyone's interest, I think, to spell that out in case it happens. It's usually not necessary in case of a midwife being employed by a hospital, because in those circumstances, the hospital would have all the agreements in place, and the patient would be made to understand before that the doctors practice for their own account. But it's obviously less obvious when there's no hospital backing and the midwife works independently. So thank you for that. That was a good question. All right, let's move on. Okay, so just in general, the HPCSA also plays a role in regulating standing doctors, not a large role, because the section of the ethical rules of conduct is very, let's call it broad when it comes to what you can do. So basically, this is what it says. It's section 9 of the HPCSA booklet 2, Ethical and Professional Rules of the Health Professions Council of South Africa. A practitioner shall employ as a professional assistant or locum tenens or in any other contractual capacity, and in case of a locum tenens for a period of not exceeding 6 months, only a person who is registered under the Act and practices or runs an independent practice, whose name currently appears on the register kept by the registrar, and who is not suspended from practicing. So the regulations does not require you to delegate to somebody with any specific amount of experience. It just basically says that person has to be registered into the Act and has to run an independent practice and should not have been suspended. Now that's what the regulations say. As I've said previously, our courts see it a bit differently. Our courts expect you, if you do have to delegate to a standing doctor, to delegate to someone who you know is capable of treating the patient. Okay, now we turn to the liability of stand-in doctors. So now we're moving away from the liability of the primary doctor for the stand-in doctors, and now putting yourself in the position of being the stand-in doctor. Okay, so covering doctors can face legal liabilities if they make medical errors, fail to meet the standard of care, or neglect their legal duties, same as any other doctor looking after any patient. So in this particular case, the matter of S versus the Life Healthcare Group is an important decision. So the facts are as follows: Mrs. S fell pregnant and was seen antelatally by Dr. M. Dr. M was then unavailable on the date of admission and contacted Dr. S to cover for him. Dr. S was phoned at 10:30 in the morning and advised of the patient admission. He then gave telephonic instructions to the nursing staff in respect of how to deal with the patient. Now, here comes the big mistake. Dr. S did not see the patient until 7:30 that evening, at which time it was too late. The baby was in distress and had been in distress for an extended period of time. There was an emergency C-section. The baby suffered from hypoxia, and the rest is history. A massive lawsuit. I think the quantum was about 45 million. So huge problems for Dr. S and potentially for Dr. M as well. But in this particular case, the conclusion, even before the matter had already gone to court, the conclusion was reached that Dr. M did nothing wrong by referring the patient to Dr. S, because Dr. S was, for all intents and purposes, perfectly qualified to deal with the doctor. So what makes this case interesting is what Dr. S attempted to argue. So Dr. S had argued that this patient did not become his patient until the time that he actually attended to hospital at 7:30 in the evening. So the argument was basically that this patient so Dr. S's argument was that I was on call, Dr. M was away, and it was his patient until the time that I had to go out to hospital at 7:30 in the evening. The court rejected that argument and criticized Dr. S quite heavily for even taking that line, and basically found that your responsibility to a patient starts at the time that you are informed of the patient and at the time that you accept the instruction to deal with the patient, which would have been at 10:30 that morning. So that's when this patient became a patient of Dr. S, as found by the Supreme Court of Appeal. Just also as a generality, I always just sort of throw this out to doctors. If you're wondering whether or not to go and see a patient, go and see a patient. It's the easiest thing ever to judge in hindsight. You haven't gone out to go see a patient, and I know it's difficult. I know it's specifically difficult at 2 o'clock in the morning when you may be at the hospital for 3 minutes only after taking one look at the patient. But in my mind, based on what I've seen, it's just much, much, much safer to err on the side of caution and always go and see the patient, even if it's only for 2 minutes, so that this line of argument can't be taken against you that you haven't gone out to see the patient. Okay, so the court rejected the standing doctor's arguments that the doctor-patient relationship only commenced upon his physical presence at the hospital, and that he was obligated to cover only emergencies or imminent deliveries. That's what he attempted to argue. Instead, the court determined that the stand-in owed the patient a legal duty as a specialist obstetrician from the moment he was notified of her admission and began managing her treatment. The court found that he was negligent in failing to examine the patient earlier and verify her condition. Ultimately, the standing doctor was found to be negligent. Question I often get as well is what happens if a specialist gets a call from a GP, which I'm told happens quite a lot in practice. In other words, the GP does not, because of the close relationship between the specialist and the GP obviously refers a lot of patients to the specialist. It's quite common for the GP to pick up the phone and say to the specialist, well, I've got this patient. Don't you want to quickly just tell me what you think about that? So not to scare you too much, but based on what the court has said in this case, you could open yourself up to a potential legal action if something does go wrong with that patient. Because as soon as you take the liberty of advising on the patient, there is a potential employer-employee relationship. There's a potential doctor-patient relation. Now, there are arguments to the contrary, but again, if I can give you any advice, it's to err on the side of caution. So if you can refrain from giving telephonic advice to a patient who you will never see physically or who you don't plan on examining yourself, you need to do that if it can be avoided at all. Again, as I said, practically speaking, it's easy for us to be armchair critics, but I'm just relaying to you what we see in practice. Okay, so this particular case that I dealt with raises the following questions: what are the duties of covering doctors? Can they be held liable for negligence? So as I said, the court concluded that the standing doctor owed the patient a legal duty as a specialist obstetrician from the time that he was notified of the admission. So again, once that telephone call is made and you are told about the patient, there's a doctor-patient relationship that, and as obviously you have to accept the patient as your patient, but the relationship begins at that time. All right. Okay. So the conclusions drawn from that case. So this was one of the groundbreaking decisions in the medical malpractice legal industry. Basically says covering doctors should treat the patient that they are covering in the same manner as they would treat their own patient. So there's no difference between you and the primary doctor. If there are 5 standing doctors, there's a doctor-patient relationship with each of those standing doctors. In other words, each of them have the same duties and responsibilities as the primary doctor has. Covering doctors can't argue that the patient only becomes their patient at a later stage. And they also can't argue that their function is merely to monitor the patient's progress. Importantly, covering doctors can't judge the patient's condition solely on what the nursing staff reported telephonically. Go out and see the patient. There's a question here, who gets held liable if the covering doctor is not reachable and is never informed about the patient? Well, it depends. So that's again from Chepa. Thank you for the question. Chepa, it depends on if the covering doctor is the doctor on call and the doctor on call is not reachable, then that's a problem for the doctor on call, because the very essence of being on call is that you are reachable. So if they're not able to reach you, which has happened in cases I've seen, with devastating consequences, then you can be found to be liable. Again, the court would look at the facts. Each set of facts are unique. The court would look at, well, why was the covering doctor not reachable? For example, if you're for whatever reason your cell phone fell into a pond or whatever. But I mean, even in that scenario, the first thing you do is you phone the hospital from your spouse's phone or from your friend's phone and say, you know, I need you to use this phone to contact me. There's all sorts of ways that you can do it. So there's usually, in my experience, very little excuse for you not being reachable if you are the on-call doctor. So I hope that answers your question. Okay. All right. Just to recap. So when does a person become a patient of a doctor? I'm not sure if anyone has heard of this term called a delict. Essentially, there's two ways that you can be found liable to a patient. The first is in contract, which is usually the standard way. So because you and the patient have a contract with each other, if you don't treat that patient properly, that would be seen as a breach of contract, and the patient is entitled to claim contractual damages from you. On the other hand, there might be some situations where there was no time to conclude a contract. In other words, when the patient is, for example, unconscious, in that case, you still have a common law legal duty to treat that patient with the requisite amount of care and skill. And a claim in that sense is what we would call a claimant delict. So there's no real difference between a claimant contract and a claimant delict when it comes to what standard of care a court requires. It's basically the same. The relief claim might be slightly different. But in essence, and generally speaking, someone becomes your patient when you see them personally, you agree to treat them personally, or you give telephonic instructions to other healthcare practitioners pertaining to the treatment. Again, I use the example of a GP. Be careful of doing that because it can open you to an argument later on that patient actually became your patient at the time that you decided to give telephonic advice. Okay, all right. Now let's move to the liability of the primary doctors, which we touched on previously. So the legal liability of doctors for the actions of covering or standing doctors can vary depending on specific circumstances. In general, doctors who request or allow another doctor to cover for them may still retain certain legal responsibilities and liabilities for the care provided to their patients during the coverage period. So delegation of duties. Sorry, Karen, I think we can do the second poll now, otherwise we're going to run out of time. So the second one is a simple one, is just for my records as well, as have you ever been sued? Yeah, there we go.
Is that a pinch? You said something?
Once I wasn't sued.
You weren't sued once.
Okay. Usually I'm sued.
Is there a question, Stephen? No. Okay. All right. Okay, so delegation of duties. When a primary doctor allows another doctor to cover for them, they're essentially delegating their duties and responsibilities to the covering doctor for the duration of the coverage. However, the primary doctor still has a responsibility to ensure the covering doctor is competent and qualified to provide the required care. Now that in some instances is easier said than done, but essentially you need to be satisfied that in whoever's hands you're leaving your patients, that person is suitably qualified to deal with them. It's an assessment that only you can make, knowing your patient, and I think more importantly, knowing your colleague who you're leaving the patient to. All right, that was an interesting poll. 74% have never been sued. That's fantastic. Very good news. 16% has, unfortunately. So just getting back, just while we're on that topic. So if you haven't been sued yet, that's fantastic. If you have, that's unfortunate. Just from the way we see things at the moment, as I've pointed out previously, is the landscape is a bit problematic, because now we're seeing spurious litigation for any and all sort of complications. So yeah, it's very important to ensure that your indemnity coverage is in place, and that you do whatever you can do to try and avoid potential complications. All right, moving on. Okay, so oversight and supervision. Okay, so even when a stand-in doctor is involved, the primary doctor may still have a duty to oversee and supervise the care provided to their patients during the stand-in. Now, that is only in exceptional circumstances. In other words, where a patient's condition is so frail or so intricately complex that a court may find that in those situations, you can't actually disassociate yourself from the patient. So whereas you, for example, you can say to the court, well, I had to go sleep because I've been awake for 48 hours. You know, that's something that's not unreasonable, but you may still need to keep your cell phone on in case the standing doctor tries to phone you to discuss something with you. So it's a situation that we don't see often, but there might be some unique circumstances that justify an oversight role, even though you are technically off duty. Again, it all depends on the specific patient. All right. So again, just getting back to the legal responsibilities, the primary doctor can be held legally responsible for any negligent acts or omissions committed by the standing doctor if it can be shown that the primary doctor was negligent in their selection or supervision of the standing doctor. In other words, selection we've spoken about. If you leave your patient in the hands of an incompetent doctor, that can result in direct negligence on your part. And same with the supervision. If it's a complex patient and you disassociate yourself completely from a very complex case, for example, you then decide to switch your cell phone off for a week or so, the doctor coming in stand-in does not necessarily know about the complex history. You can still be found to be liable if things go south for that patient. Right, and the question of informed consent, crucial, absolutely crucial. I'm not sure how many of you still rely on the hospital informed consent form. If you do, please don't stop that. Get an attorney to draft your own consent form. It's got to be unique to your practice. It's got to contain, with every procedure that you perform, it's got to contain the material risks of that procedure. Make sure that your patient understands those risks. Informed consent is the name of the game in your industry, and it needs to be taken very, very seriously. It's usually the first port of call for a plaintiff's lawyer is to take the point there was no informed consent. So again, if you don't have a proper informed consent procedure adopted, please look at that very carefully. Get consultants in. Make sure you protect yourself in that manner. Now, informed consent when it comes to stand-in primary doctors can be a problem, especially if a patient agrees to a procedure a couple of weeks in advance or months in advance, and then the procedure is then required at a time that the primary doctor is not there. Again, communication is key. So if the stand-in doctor is required to perform a procedure like that, it's imperative that you, as the primary doctor, equip that stand-in doctor with all the information that you've got, documents, clinical notes, but more importantly, consent forms. Because remember, a procedure without consent is regarded by our courts as assault, which can have very, very devastating consequences for the stand-in doctor. So it's very important that the file, that your patient file is accessible to the stand-in doctor, specifically the informed consent form. So if you have to train your office staff to assist you with that process while you're away, they can email, WhatsApp, whatever. Just make sure the informed consent document gets to the stand-in doctor. If you are a stand-in doctor in situations like this, it doesn't hurt to get the patient to complete another informed consent form. You can't have too many. You can only have too little. So from my perspective, it's just much easier, even if you're relying on the primary doctor to have your own consent form. It's much more safe.
Daniel, can I just ask you, what do you think of this practice in some hospitals where the patients get admitted and they have their documentation being filled in by the nurses? There's all sorts of things about false teeth and things, but in some hospitals they have the procedure written down and the patient signs it there and then before the doctor's actually there. Is that acceptable in a way, or is it just something that shouldn't be done?
No, look, I mean, so there's a distinction there between what you ought to do as a doctor and what the hospital ought to do as a hospital. So the hospital also has to take informed consent because of the fact that the operation proceeds in their facility. So they've got their own informed consent document, which generally includes the doctor as well. But from the hospital's perspective, there's not necessarily anything wrong with that. If you look at the hospital in isolation, the nursing staff can do that. They can represent the hospital, but just know that you as a doctor can't rely on that. So that document, if it doesn't have your input, if it doesn't have your stamp of approval, it means nothing to you as a doctor. It's imperative that the informed consent procedure happens in your rooms, if in anticipation of the procedure, not on the day if you can help it. So what I usually recommend is that you follow a standard informed consent procedure in your rooms. In other words, you take the patient through the informed consent form and deal with each specific risk, and then get the patient to sign it in front of you and put it in your file. And then on the day of the procedure itself, you can go through it again. That's also very useful. So you can say you've not only done it once, you've done it twice. But yeah, Stephen, to answer your question, I don't like that procedure, especially when doctors rely on it. It basically means nothing. You can't rely on the nursing staff to do that job for you. That is something that you have to do yourself.
Great. Pedro Pinto has actually asked, who can be a witness to a consent?
Yeah. Okay, so anyone can be a witness to a consent. You don't necessarily need a witness to a consent. You can get the signature on the document, and then that usually would hold up in court. If you can convince the judge that you've taken the patient through the informed consent form, the patient had confirmed that they understood it. So anybody could be a witness. It's always useful to have a witness if you've got somebody at your office who can stand in for that. That's always beneficial. It can't hurt. Okay, I see a couple of questions coming through. Okay, so there's an anonymous question. If the outcome in a cesarean section is adverse and it's believed it's because of a certain decision, like an emergency hysterectomy, was not taken, who is supposed to be liable? Hospital, surgeon, anesthetist, nurses, or assistant? I'm just going to read it again. If the outcome of the C-section is adverse and it's believed it's because a certain decision, like emergency hysterectomy, was not taken. Okay, so that could be potentially because of sepsis in the uterus, I would imagine. Who's supposed to be liable? Okay, whoever asked that question, it can be all of those people: hospital, surgeon, anesthetist, nurses, everyone. It depends. So, for example, I mean, your primary practitioner, your primary surgeon, the obstetrician would be first in line, because they are generally regarded in a theater setting and in a hospital setting as captain of the ship. So you would firstly look at the doctor, but again, with a C-section going south, I mean, there could be various reasons, wound complications. That again is more of a nursing issue, depending on the circumstances. So yeah, so to answer your question, depending on the factual circumstances, any of those people can be held liable. Okay, and then Dr. Phil Yuden has asked, sometimes we have to run to theater and phone the anesthetist and the pediatrician with fetal distress or cord prolapse. Is oral consent okay? Yes, oral consent is I mean, you consent does not have to take the form of written consent. It can be oral consent. If the situation is an emergency, in certain instances you don't need consent at all. You can justify it. You can justify it post facto if you can say that it was an emergency and it was in the patient's best interest, and you don't need consent at all. Those situations are quite few and far between, but yeah, Dr. Viljoen, to answer your question, oral consent is definitely fine if circumstances permit. Obviously, written consent is preferable because you've got a document to show the court one day. But in certain instances, oral consent is absolutely fine. Okay. All right. Karen, I think we can do the final poll. The final poll is: do you have indemnity cover? I would be appalled if there's anybody that says no.
But Daniel, having said that you'd be appalled, I understand that indemnity cover isn't unlimited and infinite. It is chopped off for 20 million or so. So if your settlement is 50 million, the poor person found liable is liable for the balance. Is that right?
Yeah, exactly. On that scenario, that's absolutely right. Although 20 million does not cut it in most situations. Well, I suppose for a gynecologist, certainly not. I mean, you can have, I mean, for example, a cardiologist, I would think 20 million is probably fine, but for obs and gynae, that's woefully underinsured. So if your cover is capped at 20 million, you need to have a very, very serious conversation with your broker, because there is always cover out in the market. You can always find reinsurers that would be willing to pump up that cover, even if it comes at a bit of a higher premium. It's imperative that you at least have cover for 50 million. I mean, the more the merrier. But if you do have cover, if you do catch babies and you do have cover for 20 million, that is a big problem, and you need to go talk to your broker.
So you say 50 million is a ballpark figure.
50 million is a ballpark figure. So again, if you can get more, it's always safer. The highest payout, I think, in South Africa that I know about was a Scottish baby. In other words, the claim was in euros, and that came to about 65 million. I think that was the highest one I've ever heard of. But as a generality, when it comes to CP claims, you're looking at settlements of between 20 and 40, around there. So 50 million is usually fine. But again, I mean, if you have the right broker, he or she can negotiate cover for up to 100 million. It just depends on who the broker is. You've got to make sure that you are adequately covered, even if it means paying an additional premium. Okay, I've got a question here. Can the assistant surgeon and surgeon be sued in case of serious intraoperative complication with poor outcome? Oh yes, yeah, no, that happens all the time. So, so your more experienced plaintiff's lawyers would always sue the primary surgeon and the assistant surgeon together. So yeah, so I mean, the assistant surgeon can potentially have an argument to say that that any intraoperative complication, in other words, for example, cutting a urethra or something like that, or a bladder perf, if there was no knife to skin on the part of the assistant surgeon, then there may be an argument to say, well, that wasn't me. But as a generality, you as the assistant surgeon can expect if something goes south, you probably will be included in the legal action.
Just a quick note.
Yeah.
If there's a Dr. Ifrief who has raised their hand, if they could just ask the question in the Q&A box, because raising a hand, it's a bit difficult for us to allow them to become a panelist or so forth to talk. So if they could just ask the question that they have for you in the Q&A box. Thanks.
So just to clarify that one, I mean, a lot of us use, people use GPs. You might use quite inexperienced, assistants. Are they should they fear some liability then in case of assisting with quite complex surgery that where the responsibility basically almost 100% lies with the primary surgeon? Do they need to fear the consequence as well of a complication as well then these days?
Well, it depends on what exactly the assistant does in the circumstances. So if your role is relatively superficial, then you don't necessarily need to worry that much. The difficulty with legal actions in general is that the plaintiff's lawyers don't discriminate. So they would usually use a scattergun approach. In other words, sue everyone, and then see who ultimately gets found to be liable. So for a GP who assists a surgeon, I don't think you necessarily have to be concerned about an adverse finding. The only problem that you're sitting with is you may come along for the ride. In other words, you would have to have your own legal counsel to represent you in court, where ultimately I think your case would be much easier than the case of the primary surgeon. The difficulty is just you obviously open yourself up to potentially being sued as well. So that's an unfortunate risk. But if you can, so what we generally try and do if we're appointed by the assistant surgeon initially, is we make contact with the plaintiff's lawyer immediately and explain in detail the level of assistance that we're given. And if my opponent is experienced enough, which they generally are usually, they would then let the assistant surgeon go. So there's different ways and means of dealing with it. But as a generality, you must just be mindful that if you are assisting, that you could be opening yourself up to legal action as well. But in saying that, it's usually only the primary surgeon that all the focus is on.
Daniel, it's Peter. I'm sadly that we're almost running out of bandwidth.
Yeah.
We have one anonymous question here. It looks like
Yes.
Habib from Kenya. He says, when does a patient's death, that's obstetrics or gynecology death, become a criminal matter resulting in a manslaughter charge?
Yeah. Good question. Okay, so it becomes a criminal matter when the death is regarded as being an unnatural one. In other words, and that's something that the police looks at initially. So once there's a death, there would obviously be a pathology report, and based on that, an investigator would be appointed to consider whether that death was unnatural. And if the death was unnatural, the next step is that the investigator may refer the matter to a prosecutor. The prosecutor may in turn refer the matter to an inquest magistrate, who will then run an inquest on the cause of the death. And if there was found to be negligence in the cause of the death, then that results in criminal proceedings against the doctor. So it's a very lengthy process, but that's in essence how it works. It all starts with a determination as to whether the death was natural or unnatural.
Because it puts a lot of strain and stress and uncertainty on a lot of our colleagues, myself included, because if a woman has an abruption and dies from a postpartum hemorrhage,
exactly.
now I don't want to go and sit in Pollsmoor for six years.
Yeah, no, exactly. So look, I mean, luckily our legal system has developed to such an extent that cases against doctors, especially criminal cases, are dealt with a high level of circumspection, which means that our courts generally favor the versions of the doctors, or tries to be lenient to the doctors, especially, I mean, with a abruptio. I mean, that to me is a natural cause any day of the week, and unless you can or the state can prove that you somehow should have picked it up before and should have done something to avoid it, there's going to be no criminal charge against you. I've never had a situation where an abruptio, for example, has led to criminal proceedings. The cases that end up in a criminal court are usually those cases of a gross negligence, which I think none of these experienced doctors who's on this call would ever open themselves up to, hopefully.
Great.
All right. Okay, so we've dealt with most of these things. I think we've basically run out of time. are there any final questions that people want to ask before we close?
Daniel, let me ask one final question. I mean, your talk's been wonderful, and the number of questions attest to this. If a person like me has a medical legal question, I'm not sure who to go to in general terms. It could be anything. Where do I get advice from? Because my broker's a broker, he's not a lawyer. Do lawyers offer sort of consultations? How do we go about getting advice of even of a general nature, a consent for example?
So there's a couple of ways to do it. So depending on who your medical insurer is, they would usually have a structure in place whereby they provide that service. So whether you're with MPS or Genoa, PPS, Ethical, whoever, those companies would have internal lawyers dealing with their claims who can answer your questions. And if they can't answer your questions, they would usually refer the questions to a panel attorney, which would be myself or McRoberts or anyone else that specializes in medical legal defense work. So if you've got a question, and I encourage you to ask questions if you do have it, because that's the only way that we can get to the point where we want to get to, is to try and avoid legal action, is if you ask and you get answered. So if you do have a question, phone up your medical insurer. They should have the answer already, because most of the claims handlers are very experienced. And if they don't have the answer, they will most likely refer you to a panel attorney.
Thank you.
Great. Thanks so much. Yeah, I mean, I think it's an important topic that we had tonight. And maybe something you don't think enough about. But I suppose the importance is communication, and documentation about that communication, so that you free yourself of liability. Making sure that they be able to have access to you.
And don't let your secretary be your sort of cheap assistant. Your secretary is your secretary, Steve. She doesn't give out free medical advice, because sometimes it's hilarious and heroic. So keep her as your secretary, and rather let her put the calls through to you.
Yeah, absolutely. Great. Well, thanks so much.
Thanks so much then. Wonderful having you, Daniel.
Yes.
And great thanks for sponsoring on behalf of your law firm, Everingham's Attorneys. And we look forward to another nice talk next. It's the Stump the Professors next week. And Steve, you the professor, the chief stumper professor. And once again, safe home. Steve, and thanks once again for the use of your mini bars. Wonderful.
Thank you.
And see you all over here. Same place, same time, safe home next week. Thank you. And thanks, of course, to Karim.
Thank you very much. Okay. Bye-bye.